You may have seen a viral headline saying the Supreme Court just dropped a 9-0 bomb that wiped out gun permit systems overnight. If you believe that headline, without checking the facts, you could make a very expensive mistake with your carry permit. Quick question before we continue, are you subscribed? Because what I'm about to reveal could save you from walking into a gun-free zone, a bad arrest, or a permit mistake you never saw coming. Hit that button now, because the people who wait for the news to explain gun law are usually the last to know what really changed. Here's what just happened, and here's the first thing you need to know. As of right now, there is no real 9-0 Supreme Court decision that suddenly erased concealed carry permit systems across America. That claim is blowing up online, but it does not match what the court has actually done. And that matters because fake legal hype spreads faster than real legal facts. The real permit system earthquake was the Bruen case back in 2022. That decision was not 9-0. It was 6-3, and it did not kill every permit system. What it struck down were may-issue systems that forced ordinary people to prove some special reason to carry. In plain English, the court said, states cannot make you beg for a right by proving you are extra special or extra threatened. If you are a normal, law-abiding person with ordinary self-defense needs, the state cannot deny you just because you lack a special story. But here's the crazy part. Bruen did not wipe out shall-issue permit systems. Those are the systems with objective rules. Things like age, fingerprinting, background checks, training, and paperwork. In fact, the court made clear that those kinds of systems can still exist if they use clear rules instead of open-ended guesswork. So if you live in a shall-issue state, your permit did not suddenly vanish because of some secret 9-0 ruling. And if you live in a state that tried to fight back after Bruen, your problem in 2026 is usually not the permit itself. Your problem is where you can carry after you get the permit. That is the part nobody's talking about enough. After Bruen, some states changed strategy. They stopped fighting mostly over who gets the permit, and they started fighting over where that permit works. That means private businesses, restaurants, transit, parks, beaches, hospitals, museums, and other so-called sensitive places. So the battlefield moved. Let me break this down for you. First thing, the internet keeps saying permit systems are gone. That is false. Second, the real legal fight in 2026 is whether states can turn huge parts of daily life into places where your permit means almost nothing. Third, the Supreme Court is already looking at one of those fights right now. That case is Wilford v. Lopez from Hawaii. And this is where it gets interesting. The issue is not whether Hawaii can require an objective permit. The issue is whether Hawaii can make it a crime for a licensed concealed carry holder to bring a handgun onto private property open to the public, like a store or restaurant, unless the owner gives express permission. Think about that for a second. Imagine you have a valid permit. You stop for gas. You walk into a convenience store. You grab a drink. If the rule says you needed express permission first, your permit may not protect you the way you thought. That is why this case matters. Most people think a carry fight is always about getting the permit. But the truth is, some of the biggest carry fights are about what happens after you already have the permit. That is the trap. And here's the part that shocked me. The Supreme Court has not even decided Wilford yet. It is still pending. That means the biggest 2026 case affecting many permit holders is not a final 9-0 ruling. It is an open case the court is still working through. So when you hear the court just overhauled permit systems instantly, slow down. Ask one question. Did the court actually issue that ruling, or are people mixing together old cases, pending cases, and pure clickbait? Because that mixing game is everywhere right now. Some creators are grabbing a real case about one issue and slapping a huge gun title on it and hoping nobody checks the opinion. Others take Bruen, Rahimi, and Wolford, throw them in a blender and call it one giant new ruling. That is not legal analysis. That is a thumbnail with a pulse. If you're finding this helpful, imagine what you'll learn in my next video about the 5 words that protect you when police start asking questions about your gun. Subscribe so you don't miss it, because the right sentence at the right time matters just as much as the right permit. Now let's talk about what actually could hit permit holders instantly, because there is a real story here. A court does not need to erase permit systems to change your daily carry life. It only needs to change the map. That is what many people miss. Imagine your state says, fine, you can get a permit. Sounds good, right? But then the state adds a long list of places where you cannot carry. Public transit, restaurants serving alcohol, parks, beaches, playgrounds, museums, healthcare facilities, private property open to the public unless the owner says yes. Now your permit still exists on paper, but your real-world carry options shrink fast. That is why the 2026 fight matters. It is about whether states can keep permit systems looking legal while making lawful carry so limited that the permit becomes a paper trophy. Have you ever wondered why a state would do that? Because after Bruen, States that lost on the front door started guarding the hallway. They could no longer deny as many ordinary people at the application stage, so they started building more no-carry zones after the permit is issued. And to be fair, some places really can be restricted. Even Bruen said there are sensitive places where carry bans may be allowed. Think courthouses, polling places, and similar areas. The fight is over how far that idea can stretch. Does it stop at truly sensitive places, or does it swallow normal life? That is why the Wolford case matters so much. It may help decide whether states can flip the normal rule on private property open to the public. In many places, the usual idea is simple. If the owner wants no guns, the owner posts a sign or tells you no. Hawaii and some other states tried the opposite idea. They treated silence as a ban. No sign needed, no warning needed. Permission first. Now, this is where it gets personal. Imagine you are driving across town with a valid permit. You stop at a pharmacy, then a bank, then a sandwich shop. You're trying to obey the law, but your state uses a default no-carry rule on private property open to the public. Suddenly, your ordinary errand run becomes a legal maze. Here's what most people get wrong. They think, if I passed the background check and got the permit, I'm good. Not always. A permit gives you authority to carry subject to restrictions. It is not a magic shield against every location law. Now, quick legal note. This is educational information, not legal advice. Always consult an attorney for your specific situation. There is one more twist. Lower courts are split on some of these post-Bruen laws. One court may strike part of a carry restriction. Another may uphold something similar. That means your rights can feel stable in one state and shaky in another. Same constitution, different map, different judge, different result. At least until the Supreme Court speaks more clearly. And don't miss this. A pending case can change behavior before the final opinion even drops. Police agencies watch. State lawyers watch. Gun stores watch. Permit instructors watch. Lawmakers watch. The moment oral arguments happen, people start preparing for possible changes. So yes, the legal pressure is real, but no, that does not mean a fake 9-0 ruling already happened. Hey, 73% of people watching right now aren't subscribed. Don't be part of that group. Join the people who get these gun law updates before the rumor channels twist them into panic bait. Click subscribe, because in this space, being early is a form of self-defense. Now let me give you the 3 biggest takeaways for 2026, and this is where the real value is. Number 1, Bruen changed permit law, but it did not end permits. It blocked special needs systems and left room for objective permit rules. So if somebody tells you every permit requirement is unconstitutional now, be careful. That is too broad. Number 2, the biggest current Supreme Court issue for permit holders is often where they may carry, not whether they may get a permit. That means your next legal headache may come from a location rule, not from the permit card itself. Number 3, there is no honest shortcut around reading the exact rule in your state. Not your friend's state, not some YouTube state. Your state. Here's a hypothetical example to explain this. Let's say 2 people both have valid concealed carry permits. One lives in a state with a simple posted sign rule. If a business says no guns, it must tell you. The other lives in a state with an express permission rule. In that state, silence may mean no carry. Those 2 people can walk into the same type of coffee shop and face totally different legal risks. That is how people get burned. And here's the mistake I never want you to make. Do not confuse permit approved with carry approved everywhere. Those are not the same thing. Also, do not confuse viral Supreme Court title with final Supreme Court holding. Those are definitely not the same thing. When I found out how many videos were claiming a 9-0 permit system explosion, I couldn't believe it. Because if you actually check the court's real gun cases, the picture is much narrower. The court has active Second Amendment fights in 2026. Some deal with who can be disarmed. Some deal with where you can carry. Some deal with what weapons or magazines can be regulated. But that is not the same as one unanimous decision blowing up all permit systems at once. So what should you do right now? First, know whether your state is shall issue, permitless carry, or still heavily regulated by location bans. Second, learn your state's rules on private property open to the public. That issue is hot right now. Third, if your state changes its laws after a major case, do not assume your old instructor notes are still current. Fourth, if you travel, remember this gets worse across state lines. Reciprocity does not erase local location rules. Fifth, keep your ego out of it. A lot of gun owners get into trouble because they would rather be loud than correct. But wait, there's something even more important. Even if the Supreme Court rules against Hawaii and Wolford, that still would not mean every permit system in America dies. This information could change fast the moment the Supreme Court releases its next major carry decision. Subscribe now, because the next video will walk you through exactly how to read a gun ruling in plain English before the panic merchants tell you what to think. So here's the bottom line. The viral claim is bigger than the truth. There is no real 9-0 Supreme Court ruling that instantly destroyed permit systems across America. The real 2026 fight is more focused, more technical, and much more important to your daily carry life. It is about how far states can go in limiting where permit holders may carry, even after Bruen. If you want real gun law updates without the fake drama, hit subscribe right now and stay with me on this channel. I'd rather give you the boring truth than the exciting lie, because the boring truth is what keeps you out of legal trouble. And final simple disclaimer, this video is for education only. It is not legal advice, and gun laws can change fast depending on your state or your permit status and the exact facts of your case. If you're facing a carry charge, a permit denial, or a location-based gun issue, talk to a licensed attorney right away.